Good afternoon. My name is Michelle Coleman Mays. I'm the General Counsel for the New York Public Library and your moderator for the panel this afternoon, Gender and Pay, Emerging Laws and Litigation Addressing Pay Equity. Before I begin and introduce my panelists, I like to call them my sisters-in-law, I'd like to have a fitting acknowledgement. Justice Ruth Bader Ginsburg is really the architect for the laws and the interpretation of those laws that underpin this area. She spent her life's work fighting to make sure that the sexes were treated equally. In one of her arguments before the Supreme Court in Taylor versus Louisiana, then Justice Rehnquist asked this question: "You won't settle for Susan B. Anthony on the dollar then?" I like to think that was a rhetorical question, and I don't know what her reply was, but a reply could have been, "No, Justice, because a woman's work is not worth an entire dollar." So let me turn now to my illustrious panel. We have Lynn Barrington, who is an Associate Dean, External Affairs for the Cornell S.C. Johnson College of Business at Cornell University. She is also the Executive Director of the Institute for Compensation Studies. Kelly Dermody is the Managing Partner of the San Francisco office of Leaf, Cabraser, Hyman, and Bernstein. She is also the Chair-elect of the ABA's Labor and Employment Law section. She represents clients in class, collective, and Me Too actions. And Jill Rosenberg, an employment partner at Orrick, Harrington, and Sutcliffe, LLP in New York. She has significant experience defending and advising employers in discrimination, sexual harassment, whistleblowing, wrongful discharge, equal pay. You get the drift. So I'm going to turn now to Linda because I'd like her to begin this discussion so she can level set for us. Linda, there has been a great deal of discussion about the pay gap versus equal pay. Those terms are not interchangeable, and it would be useful if you could give us your definition of those two concepts.
Thank you, Michelle. I think that's a great question because I often find that we end up talking past each other on the statistics. And I think sometimes it's because we're talking about pay gap versus pay equity or an adjusted pay gap. So when we think about that number of 80 cents on the dollar, which is kind of the average right now in the US of the pay gap, women are earning 80 cents to the dollar that men earn. We're talking about this raw or unadjusted pay gap where it's basically a fraction. We're looking at median earnings for women. This is the median is 50% of women earn above that and 50% of women earn below that. And we look at the same median for men and we make a ratio and we find that it's 80% or 80 cents on the dollar. Now that, when I say unadjusted, it's because we're not adjusting for or taking account of whether women are doing the same job or at the same level or in the same industry. So if we want to compare women and men in the same job, so we're looking at same industry, same level job, same educational background, same years of work. And so it's really more of an female apple to male apple comparison. Then we want to look at this adjusted pay gap. And that's important because when we do that and try to isolate gender separate, which is the way you'd really think about a just blunt discrimination, if all that's, you take care of everything else and the only difference is gender, that adjusted pay gap is 82 cents on the dollar. So it's not to say there's no pay gap, but it goes from a 20% gap to an 8% gap. And that's really important because if we want to talk about fixing the problem, we have to say, what are the factors that are contributing? So these are the things like women are underrepresented in STEM, or women face a glass ceiling, or women do unpaid work at home. So when we, again, look at that adjustment, we find that something like the occupations and the industry differential between where women are more represented and less represented explains about half of the pay gap. So half of the pay gap is because we are not represented in the same way in jobs and industries and occupation as men.
Linda, thank you. I want to turn your attention to COVID-19. It has unleashed havoc in the workplace, in our economy. And what have you seen as a result of this? What has changed in these last 7.5 months?
Yeah, so let me see if we can flip to our charts. And I ran a number of charts here to give us some background. So the first one is just taking a big step back. And before we even get to COVID, saying historically, we have made some gains. So going all the way back to 1890, we can see that the gap, so this is the cents on the dollar, has gained some ground here. And that we were by the 70s and 80s into the 70 cents and moving up to 80s. And we've now kind of flattened out. But this big gap is really in the pay for what women do. So if we go to the next slide, this is what I was mentioning earlier about women being represented differently in different occupations. So if you scroll down these, you'll see one of the first ones from the top down is paralegal and legal assistants. So over 86% of paralegals and legal assistants are women. And then if you keep going down, you see court and municipal license clerks. Well, that's 76% women. You keep going down, and eventually about halfway down, you get to lawyers, and you find that about 37% of lawyers are women, only 32% of judges. And if you go industry by industry, you see the same parallel in terms of sometimes being in an industry like medicine. If you look along these occupations, you see women are over 89% or close to 90% of nursing, psychiatric, and home health care aides. As you scroll down to what you might think of as the higher level medical jobs, veterinarians, pharmacists, physicians, and surgeons, you see fewer women. So this factor of women being in different jobs plays into the gender pay gap, but it also matters for COVID, because if we think about the kind of jobs that were shut down, the kind of jobs you could do at home, higher level professional jobs are things you can do at home. Some of these jobs, home healthcare aides, nursing, these are jobs where you're going to be on the front line. So the disproportionate representation of women in different jobs is part of what is impacting how they're faring in COVID. So if we look at the next chart, another—
Linda, can I ask you?
Please.
Have you, and this doesn't relate exactly to COVID, but it's something that I'd like you to offer your view on. In a profession that has historically been male and converted to being principally female, have you also seen market differences when that flip occurs?
I don't know if I'd say market, but differences. So a good example is medicine, where predominantly male dominated. And then as women came in, women tended to become general practitioners and pediatricians. The wages or the pay for general practitioners and pediatricians has fallen over time relative to the specialist jobs like surgeons, where men are still more greater representation than women. And so we do see that the entry of women into an occupation is correlated with, and as an economist, we argue a lot about correlation and causation, correlated with those pay reductions. So pharmacists is a really great example, and Claudia Golden at Harvard has done some interesting thinking around pharmacists. This is one that women are now over 60% of pharmacists, and that's a big change from, when I was growing up 2 generations or a generation ago. And part of it is the job of pharmacists has changed. They've moved into the Walgreens and the Rite Aids. It's become less of a business owner and more of an employee. That's correlated with a drop in pay, but it also has made it something that women can do. And so in the sense that it's not a 24/7 job where you're a mom and pop pharmacy and you get calls at all times of the night. It is a hourly job. You go in for your shift and you go home. And that change actually relates to the next slide on the timing, the one that's up right now, on this issue of, and how do women spend their unpaid hours? And so we still see a differential in household work. Disproportionately, women care for children and do household work. These are the numbers you see here are for families that are married couples with children working full-time. So you're married, you're working full-time. How does the time effort differ? And so when you think about that shift in pharmacy, if you can do a pharmacy shift as opposed to owning a pharmacy business, it becomes more accessible to women if they have this burden at home. This burden at home is another factor to think about with COVID, right? If we are the ones caring for household members, if we are the ones helping the children with schooling disproportionately, that's going to impact our ability to work during COVID. If you flip to the next chart, this is about women's willingness and ability to be in the labor market at all. And so you'll see, again, looking at the long history going back to the 40s, we've made a lot of progress in converging the percent of women who are working or looking for work and men, but some of that's come from the big drop in male labor force participation rate. So when we think about women gaining ground, there's always this question of, and what is happening to men, partly because there's a backlash if it feels like it's, taking away to give somewhere else. But you can see at the end of that time series, there's that dip down. And this dip that's the impact from COVID. So we could actually see in these huge charts, the impact that COVID has. And most dramatically, if you look at the next chart, this is the unemployment rate. So now we're getting into, okay, women are working, they're working in different jobs, and what's happening to those who want to work in the labor market. And what you'll notice is that before COVID, so when we were at these low unemployment rates back in January, February, and March, women actually had lower unemployment rates, they're the purple line, had lower unemployment rates than men, just by a little bit, but that reversed during COVID. So not only do we see unemployment rates spike for men and women, but women spiked higher than men's, so up to over 15% for women in April. And the gains we've made have been less for women. So we've regained a good amount of reemployment, but women are still higher than men and up at 9% as opposed to 8%. I'm almost done with these intense number charts. It's like part of the DNA of an economist. I apologize. The next chart, which has more lines on it, is important because I want to call out the differential impact that systemic racism plays in our labor market, and we see it again in COVID. So on top of the health burden that has disproportionately hit communities of color, if we look at the systemic racist labor market impact, we see that the unemployment rate for Black men and women, which is typically double what it is for their white counterparts, spiked very high. And the surprise, if anything, in COVID is actually how close those numbers were. So we actually got unemployment rates that were fairly close between Black men and women and white women. But again, the recovery has been the greatest for white men, next for white women, and the least recovery in the unemployment rates has been for Black men and Black women. So we can't forget the intersectionality between race and ethnicity and gender when we're talking about unemployment and earnings. And just to also make a point, unemployment is something we talk a lot about, but there's a really nice work that was done by Erica Groshen on the final chart that looks at job disruption. So what unemployment doesn't get at is whether you're even looking for a job. So if your children are at home and you're trying to help them with schooling, you may not even be looking for a job. So flipping to that very last chart in our series, you'll see that this total disruption number takes account of things like, well, were you working in February, but now you're not even looking for a job? And again, on the two sides of those tables, we see the gain or the recovery since April in the blue, and then June in orange and gray in for August, of how we have made progress back in the disruption, but taking account of who was actually working in February and whether you're on temporary layoff, all these things that the unemployment number doesn't actually capture. We still see that there's a disproportionate burden that's being carried by communities of color and by women relative to men. The one other point I would make about COVID is, there's also a question of these household decision making, right? Like the unpaid time, one might argue, is a choice that households are making. In some cases, organizations, mine included, asked for voluntary pay reductions, voluntary reduction in hours. We know from other research that women tend to sacrifice more. There more vacation days go unused by women than by men. It'll be interesting to see if women have also voluntarily taken hits relative to their male counterparts, and that may be something we don't know for a while.
Linda, what most surprises you about where we are now, or would you say as an economist, I told you so?
I guess what surprises me is partly that I think that we have to figure out the really hard thing, which to me is not this issue of why are we going into different jobs, and why are we going into different industries, and why are we doing differential amounts of housework? Those are things that can't be legislated. And so that's where I'm not sure it's a surprise, but I guess it's a concern that there's such a big factor that comes into play in terms of what one may call choices, or one may call societal structures that push women into different jobs and into having different ability to engage in the labor market because of decisions at home. And so, while it's not part of this, I just don't want to lose that in our conversation, because there are some very tough conversations we have to have at home, not just in the legislative halls.
I agree. And just turning back to something Justice Ginsburg once said, it's her good luck to have married Marty Ginsburg, because they were equal when it came to the home, except he was a better cook. So Kelly, I want to ask you, when we try to dig out of this hole that we're in right now, what do you think has to change or be done in order to try to regain so much that's been lost?
Wow, that is such a huge question. The pandemic has really revealed and amplified structural problems that were there long before COVID. And all Linda's charts, I think, reflect that data. We know that there has been a myth about work-life balance. We say that term, but it means nothing. Now it's basically, there is no distinction, and we all know that it was sort of false to begin with, but there really is no distinction between the paid work and the unpaid work that people have at home right now, especially parents of young children and mothers in particular. We're talking about survival and wellness as concepts now, not balance. And the good thing structurally is that I think COVID gives us an opportunity to reflect on how we've organized work, and to recognize that we have some false idols around work. The valuing or the prioritizing of people being in the chair versus productivity or contribution. The idea that that certain things have to happen at certain times of the day, and that's just how it has to be because it's always been that way, has been false forever, but now it's been revealed as impossible to achieve when people are working from their homes. So I think some of those issues, the greater flexibility that we've learned is possible in the workplace, will give permission especially in professional workplaces where people are not frontline essential workers and they can do work from home, to have more accommodating schedules. And that is going to unlock, I think, a lot of things for working parents, but also for people with disabilities, older people, and people for whom a commute is an extraordinarily expensive or long process. That can be a great equalizer in the workplace. None of that's been revealed by COVID changes the pay gap problem. And so the pay gap issues, things like how starting pay a year out of college is showing differences by gender. The American Association of University Women have done great studies about what's happening for students coming out of college who have the same degrees from the same tiered colleges in the same industry, and the first job out of college, they're making different amounts of money based on whether they're male or female. And that gender pay gap that starts in year one gets picked up for the rest of a woman's career. Because it gets picked up in the way that employers look at salary of incumbents. So they often make decisions about pay raises based on what you've made last year, and that gets reflected in future pay. Bonuses often are a percentage of base pay. So if there's a gap at the start, there's a gap in the bonus. And other employers who aren't now subject to the laws of New York and California, other places, will take a peek at what someone's earning now, or ask someone about salary expectations, and then pick up that pay disparity in all future propagations of pay. Those things have to be fixed, and we'll talk about some of the techniques, but certainly COVID will not change that. We have to actually be conscious and active and intervene in ways to disrupt that.
And so you're talking about being more of an activist and not just assuming that you rely on the kindness of strangers. But I want to go back to something that you hear when you talk about workplaces. And I get it that FaceTime is not what we think it used to be. It's more like Facebook. But I also have this gnawing sensation that people say, well, how do you create culture and collegiality? And how do I get noticed? And if I'm a minority, do I fall off the grid because I'm not Zooming when everybody else is Zooming?
Yeah, I mean, absolutely. It is a huge worry. I mean, this is the trade-off, and I'm glad you've raised it, because we've also learned through this all remote environment that there is no substitute for the immediacy of human interaction, and that there is something magical and different, chemical and different, that happens in a culture when people can just hang out and talk to each other. We lose something in terms of collaboration and creativity. And when we lose that, what does that do to attrition? What does that do when people are working in workplaces that are predominantly outside their race or gender demographic? How do they get picked up and retained and supported and become part of that culture too? So I think there's some major challenges with the opportunity that we are presented with in terms of making workplace more flexible, that we make workplace more alienated and less connective, and we lose something in the brand and the culture that we want to curate.
I want to turn to Jill, since I know your client base is made up of people like me. What do you think employers have to do or be willing to do differently in order to incentivize their staff, given everything that's been swirling around? Are they really willing to break some rules, or will they just want to wait until the past returns?
That's a great question, Michelle. I think notwithstanding the difficult times that we're in, employers do care about fairness and equity, and those principles have become, I think, even to focus even more in light of Black Lives Matter and recent events. And so I think employers are focused on these issues. And look, the bottom line always matters in business, and we know we are still in a world where we compete for talent and female talent and minority talent, and for employers to attract and retain the right talent, folks need to be paid in accordance with with their value and with the work that they are doing. and creating, flexible workplaces. I think the pandemic has revealed that we can work from home. People may not always enjoy it, but I think people realize now that FaceTime isn't so important, and flexible hours work as well. If the work can get done, doesn't matter if it's done between 11 p.m. and 2 in the morning, as long as that work is accomplished. So I think the silver lining perhaps of the pandemic is I think employers have realized that the old rules don't have to be the new rules, and that we can do things differently. And then of course employers are always going to be motivated by the law. And we're going to talk a little bit more about that. There's always regulators, whether it's the EEOC or the OFCCP for federal contractors, or great plaintiffs lawyers like Kelly, who bring large class actions that can have a huge impact on an employer or even on an entire sector. That those are always things that are going to influence how employers act. And another trend that we've seen in the last couple of years is shareholder activism, that large public corporations being pushed by individual shareholders and shareholder activist groups to disclose their pay gaps or their pay equity statistics. In other words, having those types of public disclosures, forcing the employer to then look at its numbers and disclose and perhaps remedy disparities so that it can make a disclosure that it's proud to do.
And Jill, when you talk about that, one thing that might be leveling the playing field is more transparency. That depends, I suppose, right? Because we were going to talk about this later, but just going back there, when you say that employers are getting pressure to do this, sometimes from outside parties, there's transparency and then there's transparency. And I even asked you, well, is transparency all an upside? And I think you had
So transparency within, there's public transparency, and I think even within organizations, what employers are willing to share, the idea of, providing a roster of what everybody earns and getting down to a person level may be more counterproductive. People are going to fixate on, why does this person earn this? Why do I earn that? Especially in organizations where there's high variable compensation. But the idea of reporting in a more aggregate way, what an employer's potential pay gap or pay statistics are, can be valuable. I think it does give employees hopefully confidence if the gap is small, that they are being paid fairly. If the gap is not small, that employers are doing something to remedy that.
One other thing I want to ask you about before we go to our next topic, and that's boundaries. When you talk about flexibility and the fact that you no longer have to be in a chair at a desk in an office, I've also sensed that people feel it's 24/7. I can't say I'm not available unless my iPhone broke, that you are meant to be available. And yet you need your headspace at some point. I don't know how much people respect boundaries now that we have Zoom and smartphones.
No, that's a problem. I think it's a problem for men and women. It may be a greater problem for women if they are the ones, going back to Linda's comments earlier, who are going to be the ones who are busy from 7 in the evening till 9 p.m. and people are Zooming and setting up calls in the middle of dinner time. But generally, I think in this pandemic, certainly in jobs that are white collar, where people are working at all hours of the evening, these boundaries need to be set for everyone, for men and for women.
I agree.
It can be a problem across the board.
So I want to talk about the statutory framework, and I'm going to keep with you, Jill. Can you dive deeper into the legislation, the litigation that drives federal laws, state laws, and just give us a little tour?
Sure. So if we go to the next slide in the deck, there's just the next one after that, the first statute I'm going to talk just a little bit about, the Federal Equal Pay Act, which hopefully folks know about. It's the oldest of the equal pay laws, going back to 1963. It's the basic law that says that employees of the opposite sex need to be paid equal pay for equal work, with equal work being defined as work that requires equal skill, equal effort, and equal responsibility, and done under similar working conditions. That concept of equal work is one that has been interpreted relatively narrowly under the law, and that's one of the limitations. I'm just going to give you one example, a very, I think, important Second Circuit case from a number of years ago that really will bring this to life, and for this audience of lawyers will hopefully understand and appreciate. There's a case called EEOC versus the Port Authority of New York, New Jersey. It's from 2014. It was an EEOC-initiated case, but it involves staff attorneys, in-house attorneys at the Port Authority, and a female staff attorney claimed that male staff attorneys were being paid more than she was, and that they did similar work. They were staff attorneys, but they had different specialties. One was a labor lawyer, one was a contracts lawyer, one was an M&A lawyer, and she argued, as the EEOC arguing on her behalf, that essentially an attorney is an attorney is an attorney. All attorneys kind of have to do the same things. We all analyze, we all have to meet deadlines. Ultimately, the Second Circuit rejected that argument and said to the EEOC that they needed to plead specific facts about the actual job duties that these lawyers were doing to show that the jobs themselves were substantially equal, recognizing that, for us as labor lawyers, perhaps our job has a higher value. We do more complex and complicated work than a contracts lawyer or potentially an M&A lawyer. And so those differences could essentially sink a Plaintiff's Equal Pay Act claim at the prima facie case. But the framework on the slide for equal pay is if someone of the opposite gender can show a comparator doing the same job and making more money, first they have to be in the same establishment, meaning in the same workplace. But the important part is then the employer has the opportunity, even if there is that differential, to defend the differential on one of a number of grounds that are set out in the statute, either seniority, typically somebody who makes more money each year, like in a union context, a merit system, a system that measures earnings by the quality or the quantity of work, like a commission system, and lastly, what we call the catch-all, any other factor other than sex. And I'm going to come back to that factor because I think that's the one where employers have, for the most part, been successful. If we can go on to the next slide now, just a few other things about the Equal Pay Act that are noteworthy. Very different than other discrimination laws where proof of motive or intent is important. Sometimes people refer to the Equal Pay Act as a strict liability statute. If there's a difference between a male and a female, and that difference cannot be explained by one of the factors that I just described, plaintiff wins. It doesn't matter what the intent was. Equal Pay Act claims also have a 2-year statute of limitations, or 3 if it's willful, follows the same rubric as the Fair Labor Standards Act. You do not have to go to the EEOC, but the caution with that is, unlike when somebody files at the EEOC, the clock stops until a right to sue letter is issued. Somebody goes to the EEOC on the Equal Pay Act, the clock keeps going even during that investigation, so the 2 or 3 years becomes very important. And lastly, for those who do class actions, this is a form of collective action. It's an opt-in similar to the FLSA. We can go now to the next slide, talk a little bit about this Title VII of the Civil Rights Act, again, the omnibus discrimination statute, which covers not just discrimination on the basis of gender, but all protected classes under federal law, race, religion, national origin, etc. The key difference, one of the key differences, although motive needs to be proven, the key difference in Title VII is that the comparator need not be equal. The comparator needs to be similarly situated, which is a much broader concept and will draw in many more individuals into a comparison. Title VII also includes other types of practices that could impact pay, such as promotion or steering or assignments. These cases can be brought as disparate treatment or as disparate impact, some sort of neutral program or policy that then disparately impacts one group based on gender or race. Same defenses as the Equal Pay Act, but if there is a disparate impact case, the employer needs to show that whatever practice or policy is at issue was job-related and business necessity. As I mentioned before, one needs to go to the EEOC, file a charge, and Title VII follows the Rule 23 class action mechanism. Let me just now go to the next slide, and since we are talking about Justice Ginsburg today, it's very appropriate that we talk about the Lilly Ledbetter Act because she was the architect in many ways of this law coming out of her passionate dissent in the Ledbetter case. People may remember this case. A female employee at Goodyear took her about 20 years to realize that she may have been underpaid because she didn't have access to information about her male coworkers. She eventually learned that and brought lawsuit, but ultimately the Supreme Court found that the case was not actionable because the discrimination had occurred so long ago. Essentially, when she was hired at a lower salary, the court viewed her discrimination as being sort of one continuous act, and one could not have a remedy for the current effects of past discrimination that occurred 20 years ago. Justice Ginsburg wrote a passionate dissent, and then President Obama, I think it was his first act of legislation that was enacted, was the Lilly Ledbetter Act, which now creates essentially a separate cause of action for each paycheck that may be discriminatory. Doesn't mean that somebody can go back 20 years, still has to be within 300 days of a wrongful act, and then you can collect pay for 2 years before that, but it allows for the present effect of past discrimination to be actionable and essentially would have remedied in part Lilly Ledbetter's claims. So that's a quick overview of federal law.
So before you go to state, I just have to ask the obvious, and Kelly or Linda, anybody can chime in. These two statutes were passed within roughly a year of one another, 1963 for the equal pay, and then Title VII comes on board in 1964. Yet, if you look at the charts that Linda showed us about the pay gap, you wouldn't necessarily celebrate the fact that these laws existed. And so why do you think, despite them being on the book, despite their attempt to eradicate something, it's been, at best, anemic?
Yeah, I'll take a stab at that. I mean, the most problematic aspect is that people don't know what anyone else earns in most employers. And so there's no self-enforcement that's possible. And other than, the California law that now allows applicants to inquire and get information about salary, employers are under no obligation to reveal salary information unless they volunteer it. And so people tend to just walk around not really knowing unless some coworker says something to them that indicates that they are being paid more. And that's just the random happenstance. I think also the laws as written are not particularly strong for employees. You can see there's so many elements that have to be met to show equal work. It really provides a lot of traps for the employee to get through before they can get to a liability finding. Plenty of things, technical questions that employers can raise about who is truly equal, and the sort of single establishment idea, like what is an establishment, has been challenging for employees to get through, especially if their comparators are working in the facility that's down the street from them. And so are they really the same establishment? Those are all things that are really a problem. And you see that reflected in the case law, where overwhelmingly EEO cases are brought because of promotion, termination, harassment, things that are visible, things that you can see around you, and not around pay.
So do you want to chime in, Linda?
Yeah, I would just say, I think that part of what's really important about those laws, though, is setting a larger societal context. So again, some of the research about what was really impactful in the 70s to move on this was partly changes in the cultural practice of marriage and the sense of equality and the pill. Those are two things that have been noted.
I wasn't expecting that one, Linda. I wasn't expecting the pill to come into your discussion.
It was, there is, when you try to look at what has changed, there is some real documentation around that. Was a huge ability for women to make choices about when they have children, which changes the negotiation in the household, which means your job can become as important, because those two things together, how marriage interacted with the workplace, how birth control interacted with the workplace, was what allowed women to think about careers as opposed to jobs. And when we think about closing the pay gap, it is about over the career. I know we still have a gap for those women who come out of college the same degrees as men, and there's a gap, but the gap is much smaller than
Right.
over their career, right? So it is the career path that is so key. And so I think the laws are important in part because they're very visible, and Lily Ledbetter's story got people talking, and got people talking about, can we talk about what we earn? And so even though they may be hard sometimes to execute on, that doesn't say they don't have a huge impact on the way society thinks about equality.
So Jill, I want to switch back to you now and ask you to do an overview of what's happening in the states, because it's slightly different from what's been going on the federal level.
And I think it's a great segue, because to answer in part your question, Michelle, why haven't these laws been as impactful as one would have hoped or expected? In part, it's due to the limitations of those federal laws, and what I'm going to talk about now in the state laws has tried to address that. So, for example, when we talked about the Equal Pay Act, this narrow notion of what is equal work has been limiting. Title VII has a broader definition of comparable work, but Title VII requires proof of motive. And in the pay area, motive is often difficult to prove, in part because, as I think Kelly had mentioned, there isn't a lot of disclosure and sunshine about what people make. There are other issues as well about the way pay systems work and pay decisions are made, but motive being a key element of any Title VII claim. So if we go now to the next slide, just to put this into context, starting in about 2015, California being the first statute, first jurisdiction to pass a statute, there have been a flurry of states. Probably half the states now have new equal pay laws. Many states had equal pay laws on the books. They just mirrored the federal Equal Pay Act. And what we saw as a result of the Obama administration of efforts to pass new equal pay legislation, and all the focus that we've talked about on equal pay and the limitations of federal law, that states kind of took it into their own hands and said, we are going to pass our own laws. We are going to try to address these issues and have broader, more protective statutes. And so the statutes do essentially two different things. The first is expanding the pool of comparators. And the California law being the first is a great example. It's been followed in New York and New Jersey, replacing the notion of equal work with substantially similar work when viewed as a composite of skill, effort, and responsibility, and performed under similar working conditions. Kind of a squishy concept, but you can see from the slide, there are particular metrics or points of reference, whether it's ability or education or exertion, things that will have perhaps different jobs be viewed as comparable. And I'm going to just give one quick example of how that would, actually we can use the example from the case that I just mentioned from the Port Authority case. In that case, the jobs of the staff attorneys might not have satisfied an equal pay analysis, but it's possible they could have survived a Title VII analysis, that a staff attorney, again, who did labor and a staff attorney who did mergers and acquisitions, they may be substantially similar work. They may not be equal work. And so that would be a way in which, again, a state equal pay law would provide more coverage. We can go now to the next slide. This is just another couple of examples from other states, expanding the pool of comparators, Maryland, Massachusetts, and Oregon, again, with similar concepts, comparable work, work of comparable character. What these comparator standards are really trying to do is incorporate the Title VII standard that I talked about earlier, the substantially similar, that is broader than equal work. A couple of statutes as well have gotten rid of this notion of same establishment that Kelly referred to, allowing for comparators within a geographic region or even broader. That said, geography can still be an appropriate defense. Employers can pay people differently based upon cost of living of different locations or different wage scales in different jurisdictions. We can go now to the next slide. The other part of the state equal pay laws that's important is the employer defense that I had mentioned earlier. What these new laws do is narrow the employer's defense in some way by putting higher burdens on the employer to justify those pay differences. For example, California and New Jersey, as indicated on this slide, the factors have to be applied reasonably. The factor in California at least has to account for the entire differential. The employer has to be able to show that whatever difference there was entirely due to a particular factor. And perhaps most importantly, what these laws do for the most part is narrow that catch-all defense that I referred to earlier, the any factor other than sex. Now it's at least a bona fide factor other than sex. And there will be examples in different laws as to what might be bona fide: education, training, experience, etc. And those factors have to be job related and business necessity. So you can't just say, well, education, you're hiring two people. Again, example I like to give, you're hiring two people to sell shoes, female who has a college degree in English and a male who has a PhD in math. Education's not going to be relevant to hiring that person for a shoe salesperson job in terms of what you might pay them, how you would value them. However, if you are hiring two people to be quantitative analysts, the male with the PhD in math would likely be more valuable and have better skills than the female with the BA in English. And so education has to be relevant to the job. If we can go to the next slide, just to quickly highlight, New York follows this rubric. New York has had two amendments to its equal pay law in the last couple of years, uses now the substantially similar work standard and the narrowing of the any factor other than sex to bona fide factor with some examples. And again, the factors need to be job related and business necessity. And again, all of these state equal pay laws are, as I described earlier, kind of the strict liability. If there is a difference and it can't be explained, then the employee wins. So that's a quick overview of the state equal pay laws. There has been a fair amount of litigation that has arisen so far, a lot of it in California since it was the first law that was passed. I think courts are still trying to figure out what some of these terms mean. Again, what is comparable, what is substantially similar in this context. But I think this is probably the wave of the future where we are going to see more litigation as opposed to under the Equal Pay Act.
And Jill, would it be fair to say that the clients you counsel are being proactive in how they change certain things within their systems rather than waiting for someone to sue them?
Sure. So I mean, that's certainly the notion that jobs need to be compared on a broader basis. And so again, that traditional notion of, well, we're just going to look at people who do the same exact job and see how their pay aligns, whether it's through pay audits, which we'll talk about a little bit, or other proactive efforts, or even just going through pay processes, recognizing that who is an appropriate comparator needs to be looked at more broadly across jobs, across geographies, across locations, and making sure whether it's setting initial pay or whether it's making pay decisions, again, that broader lens is being focused on. And then also thinking about when requests are made for pay exceptions or pay increases, and understanding what the reason is for them. There needs to be a good reason. It's not just any reason, right? It's got to be a bona fide reason. And so, you know, really having more rigorous review of exceptions and differences, and whether it's at hiring or again, when individual pay decisions are being made where there may be a fair amount of discretion.
And as you said, that this seems to be the wave of the future. And so what was rumbling in my head is when people say location, 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 it may be look at the location that has the right laws if I'm going to go work there so that I can bring the right claims. Kelly, let's turn to you. How does this factor into litigation strategy, and what groups of people are you concerned might still be left out? And I'm talking about low-wage workers.
Yeah, absolutely. I mean, it's really a struggle. If we're talking about, just for a second, individual cases, not class or collective action cases. You're talking about people who, I mean, maybe they're earning $40,000 a year, And for them, you know, if they have a salary shortfall of $5,000 or $8,000, it's extremely meaningful. But to actually litigate that claim is economically irrational for a lawyer to do it. Might be out of the realm of the ability of a person to sort of take on a filing fee and all the things that would be required to prosecute a claim. And so it's really scary to think about how this whole sort of swath of workers are sort of, you know, they can't really avail themselves of the court system. Now, we do have, you know, government agencies and fantastic people. You know, the New York City Human Rights Commission is amazing, but they only have so much staff and so much bandwidth. And so there's just a vast amount of the economy that is not going to see that kind of rigorous enforcement in the absence of some type of, you know, collective action or, you know, private class action mechanism. And of course, that's being then eroded by arbitration issues and by the various rules that apply to class and collective certification that are very challenging. You know, so I think there's a reason why we're seeing more and more emphasis on government regulation, because we have seen that like court filings and prosecutions and all that are just not doing the job of closing the gap. But we have to have other ways to self-enforce, and certainly all the external pressures that Jill talked about, the shareholder initiatives. I'd also say kind of the name and shame stuff happening on social media. Like, I don't really like justice by the mob, but in the absence of justice, the mob will fill the gap. And so people have taken to social media to basically pressure companies to hire certain people, to hire outside experts, to do pay studies. And what's been happening in the UK and the European Union around publicly disclosed pay gap studies, as fraught and imperfect as those studies may be, and actually showing apples to apples, I don't think they even pretend to do that. They do name and shame, and companies are extremely sensitive to that, especially, you know, financial services companies, technology companies, companies that have brand concerns. And the more regulation we have that causes companies to have to disclose, the more chance we have of getting closer and closer to professional pay systems that are justifiable if you had to publish them in the New York Times tomorrow. And in the absence of that, you know, what we see is that inertia doesn't generate fairness. So I see more and more legislation happening, and I don't necessarily see more and more private litigation being the solution to it, even though I you know, embrace these laws and they're very employee friendly. You know, we're not going to get there through that angle alone.
So that really leads nicely into the next area that I'd like to tackle, which is salary history and pay transparency, and how legislation has really found its way into those areas and what it means and what issues it's raised. So Kelly, why don't you continue your line, and then I want to go to Jill. Go ahead.
Yeah, great, thank you. Jill created these great slides. I had nothing to do with them, but Jill's slide, the next slide over, will also show, I think, the New York salary history. So in New York, we have, as you can see, this change in 2017, that it's sort of largely picked up across New York State this year, 2020. And this is about using prior salary and inquiring about prior salary of applicants, something I alluded to in my opening comments, that is one of the biggest challenges for women and people of color of all genders, is dealing with the impact of sort of societal discrimination or societal unequal pay getting propagated or replicated at all future employment settings. So every time you go to a new employer and you write on your application, what's my current salary? And then the employer goes, oh, I'll pay, you know, $1 an hour more than that, or I'll pay 5% more than that. And that'll be really great for that employee. They'll be making more. Well, if that employee structurally is making less because he's sitting in an economy where women are valued less or people of color are valued less, then that gets picked up, you know, forever. So having a salary transparency rules and salary history rules means that you really cut down on the chance that at hiring, you're going to be picking up differences in value that are purely a function of historical undervaluing of certain groups. And then the transparency issue is sort of slowly rolling out. In California, as mentioned, we have this salary transparency law under our Equal Pay Act, where applicants, it's kind of a curious law. It's applicants, after they've had an interview, can ask to have salary band information for the job for which they're applying. So the pieces of that are employees don't have that right under law, only applicants, and not all applicants. Applicants that are sort of deeper into the application process are able to ask for this, and they can get salary band information or hourly rate information. And some of that is a little bit up to the eye of the beholder of what that band will mean to an employer. But generally speaking, you should be told what the salary market rate is for the job. I think all of this, again, is kind of just tinkering at the edges of what is the problem here, which is, pay secrecy and the possibility that there can be inappropriate subjective decisions about who will be paid more purely because maybe this person asked for more, maybe because this person works for a supervisor who just really wants to hire them and they're earning more someplace else. And so they're willing to pay them more than incumbents just to get that person in the door, even though that person won't be doing anything different than incumbents. And problems like that get, again, picked up and replicated and pay over time. So I think that this is sort of, I think, Linda, your point that even though this particular type of salary transparency law won't unpack all of it, it starts to level set about what our expectations should be about how we're paying, and that it should be rational, and that we strip away pay decisions based on sort of individuals or personality of individuals, but we're looking at the content of the job and how are we paying jobs, and that jobs that are substantially similar should be paid the same, irrespective of the person that populates them. Because if the jobs are similar, the people in those jobs have the same skills or the necessary skills that are related to that job, and there shouldn't be these differences. And if there are, they need to be fixed.
I can tell you right now, one of the things that you find, I used to head up HR for one of the companies that I was with for North America, and you find a manager who's fallen in love with a candidate, right? They walk on water, they fly through the air. And then you come back and say, well, wait a minute, if we look at who's doing a similar, and this is before all these laws, Kelly, the person starts glaring at you saying that I'm going to lose the candidate because of your stupid rules. Well, I guess so. That I will not endear myself to anyone. And I don't know if you see this, Jill, but that is one of the toughest things you have to grapple with, is when you go out into the job market and find someone who's making substantially more than someone in a job that's very similar.
Yeah, no, these laws do allow, certainly in New York, that if somebody volunteers the information, it can be considered. And in many jobs where there is competition, it's going to play out that way. The employer's going to make a good faith offer, hopefully, and the employee's going to say, hey, I'm not going to move because that's not enough, because I'm making the same, or actually I'm making more. I need to be paid X, or I was making X. And so it does start a negotiation. So it's not always going to eliminate the negotiations, and it's not going to eliminate the back and forth. I think employers have been, as I said before, more rigorous in making those exceptions and saying, are we willing to lose this person? We can find somebody else, or, this is a very highly specialized area. We really need somebody. It's going to be really hard, and we're willing to pay, above quote market or above what others are paid, recognizing that, Michelle, as you said, that does create risks down the road. And so employers are still making those business decisions that if it is a critical hire and the person is negotiating, male or female, and says, I'm not coming because you need to pay me more to move or to take risk in moving, then the employer is going to make that determination whether to take the risk or not.
So I'm mindful of time. We've got about 10 minutes left, and I want to get to an area that I don't want to turn to Linda, and the research around the paradox of meritocracy.
Yeah. So when you think about meritocracy, I mean, some of this is what we've been talking about, right? So you have a candidate that is really good, that someone said is very, has lots of merit. So how do you, break the rule for that? And so when we look at what's happening, I think the pay gap and the transparency are interesting buckets of legislation, because the pay gap is sort of, the salary history band, sorry, is sort of saying what you can't ask, and transparency is forcing information into the market. And so I would just make the comment again, as an economist, there's no free market advocate or mainstream economist that should object to transparency laws, because the market system works on information. So the reason markets work is because you have information. You know what the price is, and as a consumer or a supplier, you can pick and choose, not worth it or worth it. If we don't have pay transparency, it actually messes up the market functioning. So in terms of people who want to argue, that we need to have the market work, then they should be fully supportive of more transparency, because the more information, the more accurate and efficient the market can be. So that's just a little ideological statement there.
All right.
But when we look at that, and it goes back to what Kelly was saying, the way people are reacting in Europe to the UK having to put out these gender pay gaps, and that they don't want to report this because it looks so bad. So the point is that why does it look bad? And they say, well, it's not a good thing. We shouldn't have to release this because it's not an apples to apples comparison. It happens that all our women are in low paid positions and all our men are in high paid. So if you made it comparable, they wouldn't look so bad. And the point is, but now they're being forced to tell that whole story. Mm-hmm. They have to explain, it's not that we are sexist in how we pay people, we just put all the women into low paid positions. Right? So that's the conversation you have to get into the market. So a woman can say, well, do I want to go to that company where that's the way they structure career paths, or do I want to go somewhere else? So there's been some interesting research done on the Danish law, which was one of the earlier ones in Europe. This was in 2006. And that law required employers to tell employee representatives of the gender pay gap, but not the public. But so it was informing basically employees. And what they found there is that it really has had an impact on reducing the gender pay gap, but it's done it by slowing the growth in male earnings, not raising the growth rate of female earnings. And so
so in other words, everybody lost.
Well, no, because that's the apples to apples comparison, right? So in a given job, women's pay wasn't growing as much, but they were more likely to be promoted and hired. Okay. So it closed the gap by essentially, one scenario would be a man comes in and says, I want a raise. And to Jill's point, the employer needs a good reason now to do that. And they don't have that good reason, so they don't give that raise. That suppresses the growth rate of the male earnings. But a woman is more likely to get hired into that kind of job, and that's what gives the pay raise. So I think in general, the research is showing that more mobility is good, and information helps that way. The more information you have, the more likely a woman is going to be to make a move, because you can see the pay difference. And that's where we're also seeing how the salary history bands are having an effect, is more on when people make movements. So one of the studies that's been done on California did show that there was a gap closure, taking the gap and reducing the gap by about 20% for people who switched jobs. So as you switch jobs, you're more likely to be able to get a bump in earnings, and the salary pay gap is associated with that. The other thing that it's done, according to some research that was done looking at online platforms, so they basically did an experiment where they gave some history on some people and not on others. And what they found is that employers took more time, asked more probing questions, brought in more callbacks of people with lower wages than if they had the salary history. So by limiting the history, you were pushing employers to get to know applicants better, and it increased the pool and also the pool at the lower wages. So these two different pieces of legislation working on different sides of the information gap, I think are really promising for, especially for people who, when they make job changes.
Got it. So I want to just move quickly to this whole area of practical guidance with the compliance challenges that employers would face, Jill, when you've got all this legislation and activists in the space. What, from your perspective, are some good practices that employers can actually use in light of this environment?
Sure. So I would say perhaps the most impactful and effective thing an employer can do is do a proactive pay audit. It can be across the entire organization or within a sector of the organization, but the purpose of that type of a pay audit or pay study, it's to identify systemic issues, not going to find every single area of risk, but to identify systemic issues and hopefully remedy those. The caveats, of course, are that if an employer is going to head down that path, it has to be willing to make the adjustments to spend the money that it will take to help close those gaps. Typically, it is recommended, we recommend certainly on the employer side that those pay audits be done as privilege audits. They are for the purpose of assessing legal risk, of assessing compliance with state and new state and federal laws. And so, the employer should be free to dig into its numbers and to analyze and see if there are issues and problems. Are there pay differences? Typically, the way an audit would work is it's a, not to get too wonky, it's a multi-factor regression analysis. Employers looking at the drivers of pay in any particular organization and looking at how those factors play into pay and whether it creates differentials between men and women or individuals of different races. If there aren't good explanations for those differentials, then the employer may choose to make an adjustment to close that gap and to minimize risk. And I know Kelly has a view on the privilege issue. I do think that there are good arguments to maintain privilege. Where the issue comes up is potential waiver when employers then choose to disclose information from a pay audit or separately disclose pay gap or other pay equity information, whether they will have waived that privilege. And, it's a fine line to walk. I think employers understand the risks and try to do it in a way that minimizes it. But, employers are not going to do these types of proactive audits, if the no good deed goes unpunished rule goes into effect. And so that is an important step. The other thing I just want to highlight in terms of practices, I think we've talked about it, is really, having much more rigor around the pay, certainly around starting pay. I think employers have moved away because so many states have the prior salary bands, to rethinking compensation at hire, to really forcing employers to have a set of protocols to document, so that 10 years from now when someone says, why did Kelly get that at hire? Somebody will actually know what her starting salary was based on. But more importantly, if those exceptions are going to be made, if that, negotiations going to occur, that, multiple sets of eyeballs have gone on that and are comfortable that this is justifiable, under the circumstances and not going to lead to risk of litigation. So I think the documentation and the rigor around compensation practices is probably the other most important thing.
So Kelly, I'm going to ask you the last question, which is kind of the last question. What are the most common mistakes you see being made especially when you start talking about pay equity audits?
Oh gosh, where do you start?
Very briefly.
Yeah. So I think, there's how they're constructed, who does them, how often they're done are all big issues. So, this is something that should be a regular part of business operation. So every single year, And especially, large employers that have a lot of moving parts need to know what's happening and nip it in the bud if there's a problem. So, and I think that raises itself a host of privilege questions, but I think it should be a regular business operation to be concerned with one's pay structure. The other thing is to, as Jill, I think very correctly pointed out, and this is something where I think Jill and I have overwhelming agreement on a lot of this audit stuff. You got to actually fix the things that you discover. And folks that just do the audit because they want to check a box to say we've had an audit, or they want to do an audit so they can tell those shareholder activists or their employees, oh, we audit our pay. I think are missing a huge opportunity to actually ferret out problems and to address them timely. I think the other thing is doing audits that are poorly constructed so that you essentially are going to figure out that there's no problem before you even do the analysis. And I say that this is really for large employers that have populations that they can sort in different ways, so that it's possible if you were to slice the population small enough, you could never possibly see a pattern. That's not going to be an audit that's particularly helpful. And so folks have to be willing to accept the possibility that we're going to get an answer that's uncomfortable, because again, the challenge here is to make sure that you eliminate risk, you do the right thing, and you pay people fairly. Sometimes, as I think Jill said, you're not going to see everything. And in smaller employers, doing a statistical study is not going to be the full answer. And sometimes you just have to eyeball people's pay. So in my own law firm, I wear the hat also of our HR partner. I'm a liaison to that department, and we have 240 people or so in our headcount. And I personally look at every single pay decision and verify, the equal pay analysis for all of them. And what helps, and I'll say this, kind of as part of pay equity or pay auditing, what really helps when you're looking at pay is to strip away kind of what you've done historically and ask the question, how should these jobs be paid and how should they be leveled? So if you are having kind of a base pay system where, associate first year is the same pay as every other associate first year, and you're tracking that, you're not going to have big surprises at the end of your equal pay audit. But if you're having one-off decisions being made because of what you just said, Michelle, someone really loved a candidate, and now that candidate is making more than other people in the pay structure, your pay audit is going to be a mess. So getting your construction right around your pay system really leads to a pay audit that has few messes to clean up at the end, that doesn't need to have strange construction to get to a place that you can address the challenges.
Thank you, Kelly. So I'm going to end this panel where I began by quoting from the remarks that Justice Ginsburg gave at the time she accepted the Thurgood Marshall Award in August of 1999, because I think they are equally applicable to her. Good human, advocate of extraordinary talent and vision, a woman whose work and life this nation has enduring cause to celebrate. So I want to thank my sisters-in-law for sharing your experiences and your guidance and your insight. And I especially want to thank Justice Ginsburg for leaving a solid foundation on which all of us can continue to build. Thank you.
Thank you.